Hey everyone, here to talk about the San Francisco Art and Athletics Incorporation versus U.S.O.C. case is Venetia Bradley.
Nora Hogue.
Ryan Paddock.
JJ Boucher.
Andres Urbina.
So this case is a federal case that began in the U.S. District Court for the Northern District of California. The case began in 1982 when the United States Olympic Committee sued San Francisco Arts and Athletic Incorporated over their use of the word Olympic for the event they were hosting, the Gay Olympics. Shortly before the scheduled first day of the Gay Olympics, the U.S. District Court granted a temporary restraining order as well as a preliminary enjoinder against SFAA. Following further proceedings, the U.S. District Court granted the U.S.O.C's motion for summary judgment. The court ordered a permanent injunction against the SFAA and ordered that the SFAA pay the U.S.O.C's attorney's fees. Following this ruling, the SFAA appealed to the U.S. Court of Appeals for the Ninth Circuit. The appellate court affirmed the district court's ruling but reversed the award of attorney's fees. The appellate court found that this act gave the U.S.O.C. exclusive use of the word Olympic without requiring them to prove that any unauthorized use of the word was confusing. It also ignored any defenses available to the SFAA under the Lanham Act for a trademark violation. While the SFAA contended that the U.S.O.C. was discriminatory in its enforcement of their rights, this was termed a difficult issue as the court found that the U.S.O.C. is not bound to uphold the Constitution since it is not a state actor. The court found that the U.S.O.C.'s use of the word Olympic and its symbols can be protected without violation of the First Amendment. The Ninth Circuit Court denied the SFAA's petition for rehearing en banc in April of 1986. With this decision, 3 judges strongly dissented, citing that the interpretation of the Lanham Act raised issues with the First Amendment. In August of 1986, the SFAA appealed the case to the U.S. Supreme Court, which granted certiorari, and the case was heard in March of 1987.
So the Supreme Court also rejected San Francisco Arts and Athletics Incorporated argument that authorizing legal rights to the U.S.O.C. over the term Olympic is in violation of the First Amendment because the First Amendment doesn't protect the use of the word for expressive purposes. And also, in addition to that, the Supreme Court did reject the SFAA's claim that their equal protection was violated by the U.S.O.C. because the U.S.O.C. isn't a governmental actor, and because they aren't a governmental actor, the Fifth Amendment does not apply to them.
Back in 1976, Congress amended the Lanham Act for the U.S.O.C. to use their the name Olympic, Olympiad, or Citrus Altus Fortis, or any combination of these words, which gave the U.S.O.C. exclusive rights to those since they held the trademark for the word Olympic. The SFAA sought to sell merchandise with Gay Olympics printed on them, which is a violation of Section 10 in the Lanham Act. And these were the main arguments that the court used for their opinion.
For the dissenting opinion is that the U.S.O.C. should be subject for violating the Fifth Amendment by discriminating the gay athletes who were set to participate in the SFAA's Gay Olympic Games by not allowing the SFAA to use the word Olympic in the title of their games. The SFAA believed that it was because the U.S.O.C. didn't want the word Olympic to be represented by gay athletes, which, if you do the research, there are other organizations that use the word Olympic while hosting their games, so the SFAA just saw that as a problem. Along with that, the U.S.O.C. should not be treated as a private entity but rather as a government actor that would force them to abide by the Fifth Amendment, and that would protect the SFAA's right to use the word Olympic in their games. The U.S.O.C. could be proven to be a government actor and determined by that because the U.S.O.C. represents the United States in international competition and coordinates with the International Olympic Committee that represents representing the United States as such. The U.S.O.C. was unable to challenge the government's decision to boycott the 1980 Summer Olympics held in Moscow to send a message condemning the Soviet Union's invasion in Afghanistan. The dissent opinion also found that there was a violation of the First Amendment because the SFAA wanted to use the word Olympic in order to spread the message that homosexual men and women in the United States could move more forward into the mainstream society and to further acceptance. So with the U.S.O.C. not allowing them to use the word Olympic in their title for their Olympic Games, it didn't allow for the SFAA to express their idea, which is where the First Amendment violation could be found.
All right. Relevant law. San Francisco Art and Athletics is the plaintiff while the U.S.O.C. is the defendant. The SFAA is a nonprofit company that is located in California. They wanted to include the name Golden Gate Olympic Association. However, the California Division of Corporation did not permit them to use the word Olympic. In 1981, the SFAA incorporated and promoted the Gay Olympic Games. The organization was expecting individuals from different cities in the world. The games began with a ceremony. 2,000 athletes carried the torch from New York City to San Francisco at the Kessler Stadium. The final athlete was supposed to light the Gay Olympic flame. The competition involved a team contest. The court had recognized that national protection of the trademark since the trademark race competition. In the Lanham Act, Congress had developed a system to safeguard the trademark. According to Lanham Act Section 45, the trademark is any name, device, word, or any combination that has been implemented by the merchant or manufacturer to distinguish or recognize their product. Under Section 32, the possessor of the trademark is safeguarded from unapproved usages that are more likely to lead to misunderstandings, mistakes, or deceits. The SFAA argued that the principle prohibits the assembly from allowing the U.S.O.C. to select the control of the World Olympics. The SFAA view the word as common. U.S.O.C. shouldn't be required to prove that the World Olympic would cause confusion to the general public. Section 110 relates to the use of the trade-off to motivate the selling of products. The application is towards commercial speech. In the First Amendment, commercial speech had received a limited form of protection. In the court, the SFAA stated that the World Olympic was meant to portray a political declaration concerning homosexuals in the community. The SFAA said that Section 110 has supposed the political speech. That's it.
All right. Thank you for listening, and we hope you enjoyed our presentation.